Good afternoon from Hong Kong. This is Sarah Grimmer, the Secretary General of the Hong Kong International Arbitration Centre. Welcome everybody to the third webinar in HKIAC's series of 14 that we are conducting in 4 language tracks: English, Chinese Mandarin, Korean and Russian. Today's webinar is on the Hong Kong Mainland China Interim Measures Arrangement, and it's divided into 4 parts. First of all, I will give a presentation on HKIAC's practice and experience under the arrangement. Second, we will hear from Helen Shi, partner at Fangda Partners in Beijing. Helen has extensive experience in Chinese arbitration as well as international arbitration, including Hong Kong seated and HKIAC arbitration as counsel, expert, and as arbitrator. And she will be speaking on her experience in seeking interim relief in mainland China under the arrangement. Third, we will hear from Ing Lung Yang, partner at Latham & Watkins in Hong Kong, HKIAC council member and member of HKIAC's appointments committee. Ing Lung has extensive experience acting as arbitrator and for corporate clients in international arbitration, complex commercial litigations, and particularly in cross-border disputes involving Greater China. And his presentation will focus on seeking interim measures in Hong Kong under the arrangement. And the 4th part of today's session will be devoted to answering questions from you, so please do send them through as we go along through the message service. Okay, so first of all, what I would like to do is to introduce briefly the arrangement for the sake of those who may not be so familiar with it. And I would like to do that by reference to 4 important dates. The first is the 2nd of April 2019, and that is the date when the final text of the arrangement was concluded and signed between the Hong Kong SAR government and the Supreme People's Court of Mainland China. That signing took place in Hong Kong. Then later in September, the 25th of September, just a few days before the arrangement came into effect, HKIAC was recognized as a qualified institution under Article 2.1 of the arrangement, and I will speak during this session a little bit more as to what that means in terms of HKIAC's involvement in applications under the arrangement. The next important date was the 26th of September. That was the date that the Supreme People's Court of Mainland China published a note on the interpretation and application of the arrangement. This is a very important note. The arrangement, of course, is a brand new instrument, and the SPC note provides the official guidance issued by the highest court in the mainland for intermediate people's courts, which will deal with applications under the arrangement, as well as qualified institutions under the arrangement, and also for users who are applying under the arrangement. The SPC has also issued 12 template documents that parties may use to submit applications for different purposes under the arrangement. The SPC note, as well as all of the templates, are available on HKIAC's website. And then, of course, the 4th and final key date was the 1st of October 2019, and that is when the arrangement came into force. And in fact, here at HKIAC, we received the first application under the arrangement before the arrangement had come into force. We knew that parties were waiting for the arrangement to come into force, but with respect, the arrangement only applies to applications filed on or after the 1st of October. So in that case, we worked with the applicant and they resubmitted once it had come into force. So what does the arrangement do? The critical point of the arrangement is that it allows parties to arbitrations seated in Hong Kong to seek interim relief from mainland courts. This was not previously possible. Before the arrangement, interim relief from mainland courts was only available to parties to arbitrations on the mainland. And therefore the arrangement sets Hong Kong apart as the only jurisdiction outside of mainland China where parties to arbitrations seated therein can obtain interim relief from a mainland court. And this represents a significant commercial advantage to seating a case in Hong Kong when the successful enforcement of an award implicates assets on the mainland, or it is necessary to protect evidence or control conduct on the mainland to safeguard the arbitral proceedings. The kinds of interim relief that parties to HKIAC Hong Kong seated arbitrations now have access to on the mainland include the preservation of assets, evidence, and conduct, and that is in accordance with PRC law. Before an award is issued in an arbitration, parties to the arbitration can apply for such relief, either before or after the commencement of the arbitration. If a party applies for interim relief before an arbitration has been commenced, it must then commence the arbitration within 30 days. The arrangement is a reciprocal arrangement in that it also provides that parties to arbitrations administered by a mainland arbitral institution may apply to the Hong Kong High Court for interim measures pursuant to Hong Kong law. However, this was previously possible before the arrangement came into force, because Hong Kong is one of several jurisdictions in which the courts will issue interim relief in respect of arbitrations seated outside of Hong Kong. And Hong Kong courts have done so in the past on multiple occasions. What is special about the arrangement is that it connects two legal jurisdictions that are different at multiple levels in an important way that is of commercial significance to parties. Hong Kong, of course, is a common law jurisdiction. Mainland China is a civil law jurisdiction. Hong Kong's arbitration legislation is based on the 2006 antitrust model law, and mainland arbitration legislation is not. The two jurisdictions have very different systems when it comes to interim relief in support of arbitration. In Hong Kong, interim relief in arbitration is available from an emergency arbitrator or an arbitral tribunal or the Hong Kong courts. And parties can submit their applications for interim relief directly to any of those entities. And it is available in ad hoc arbitration as well as in administrated arbitration. By contrast, in mainland China, interim relief for arbitration is only available from the courts, not from the tribunal. And parties submit their applications for interim relief to the administering institution. There is no purely ad hoc arbitration on the mainland, and the institution submits the application to the court. And what the arrangement does is it makes interim relief available to Hong Kong seated arbitrations in a way that resembles how interim relief is dealt with on the mainland, in that it is only available to administered arbitrations, and there is a role for the administering institution in the process of submitting the application to the court. What I will do now is I will give a statistical overview of the applications that we have already seen at HKIAC, and then I want to talk about some of the issues that have arisen in the applications. Since the arrangement came into force on the 1st of October 2019, we have processed 18 applications. 17 of those applications were for preservation of assets, and 1 was for the preservation of evidence. And that involved evidence relating to the operational decisions, financial decisions, and managerial decisions of a company that were related to the dispute and under the control of a respondent. The applications have been made to intermediate people's courts in these 9 cities. All of the applications that we have seen have been in respect of arbitrations that have already been commenced. The total amount claimed over all applications is 6.3 billion RMB, or 890 million US dollars. 7 court orders have been rendered to date, and those successful applications cover a total of 2.5 billion RMB, or 353 million US dollars worth of assets. We also know that another application is imminent. It will be granted soon. The court is in the process of freezing the assets, and that order will be in the amount of approximately 170 million RMB. These seven, we've received the court orders that have been granted from courts in these 7 cities. What is also very interesting to note in respect of the applications that we have seen is the nationality of the parties. So here you will see that we have received what the applicants, 68% of the applicants in the cases are foreign parties. So we've seen parties from Hong Kong, Switzerland, the BVI, Singapore, Samoa, Taiwan, the Cayman Islands, and Japan. And 32% of applicants are from mainland China. Then with respect to the respondents, 56% of the respondents have been mainland Chinese parties, and 44% have been foreign parties from Hong Kong, the Cayman Islands, BVI, and the Netherlands. And we've had 3 cases that have been only between mainland Chinese parties. And this is, I think, significant to note because it may be contrary to what one might expect when thinking about the arrangement, in that the arrangement does not just benefit foreign parties, but it also has benefited mainland Chinese parties. And foreign parties with assets on the mainland make up almost half the entities in respect of whom preservation orders have been issued. So what has been our experience in processing applications under the arrangement? And what are some of the issues that have arisen? The first thing to note is that under the arrangement, when a party makes an application to a mainland Chinese court, it must include in that application the documents that I have listed here in accordance with Article 4 of the arrangement. And you see that one of those documents is a letter of acceptance of the case from the administering institution, so in our case, HKIAC. Now, we can issue a letter of acceptance in respect of an application once an arbitration has been commenced, and it comes under our administrative auspices. When a party requires HKIAC to issue a letter of acceptance, what they need to do is submit a request to us for such a letter, accompanied by a copy of the application for interim measures, including all supporting materials. If the application is in respect of interim relief that has been applied to a mainland Chinese court before the arbitration is commenced, and the mainland court has issued a decision, then when that party commences the arbitration at HKIAC, they should also submit a copy of that decision to us. We do not charge any fee for providing a letter of acceptance under the arrangement. When we receive a request for a letter of acceptance, if all documents are in order, we issue it on the same or the next day. We treat applications for a letter of acceptance on an ex parte basis, unless the applicant indicates otherwise, and we issue the letter in Chinese. We will provide a copy of the letter of acceptance to the applicant by email under a cover letter, and we will also deliver the original hard copy of the letter of acceptance to the applicant in a sealed envelope. And with that, the applicant can then submit the full application to the mainland court. All of this information is available on our website. So what issues have we seen arise? There are 3 that I will speak to. The first involves the text of the arrangement and the text of the SPC note. Article 3 of the arrangement says that the application for interim measures shall be passed on by the institution to the court. However, the SPC note states that a party may submit the application to the court directly. Now, in light of the SPC interpretation, HKIAC provides the letter of acceptance to the applicant, and then the applicant submits it and the rest of the materials to the mainland court. And in our cover letter to the applicant, we provide a copy we refer to the SBC note and we provide a copy of the SBC note to the applicant. Now, you will recall from what I said earlier that on the mainland, it is typical for the institution to submit applications to the court. But the SPC, when thinking about how the arrangement would operate in practice, was sensitive to the fact that the practice of filing applications through institutions was not ideal under the arrangement. And therefore it provided that applicants could file applications to the mainland Chinese courts directly. And the reasons it gave for this departure from the practice on the mainland were that if a Hong Kong arbitral institution is to submit an application to the mainland court, it can lead to a long delivery process, and this would not be consistent with the feature of urgency inherent in the preservation process. And indeed, in practice, it is generally quicker for a party to submit its application to a PRC court directly, because often the party will instruct PRC counsel, who will know the quickest way to file documents with a particular court and also be able to make sure that the documents reach the right department or the right judge. And that's not something that Hong Kong-based institutions are necessarily familiar with. It also means that applicants can keep control of the timing of their submission. On a few occasions in our experience, after we have submitted the certificate to the applicant directly, the court has requested that we submit the application to the court, and we have done that. However, we expect that over time, the courts will become more familiar with applications under the arrangement and will accept the filing arrangements in accordance with the SBC note. The second issue I can deal with briefly, and that is that in a few cases, courts have requested HKIAC to confirm further information in respect of the arbitration after the application has been submitted. And those requests are typically made orally by the court to the applicant and then relayed to us. And to give you an example, we've been asked to confirm the case number of the arbitration, the date of the commencement of the arbitration, the parties to the arbitration, and all those kinds of points are very easy to deal with. But we've also been asked to deal with other points, to confirm other points that could be more complex. For example, whether the parties have agreed to the arbitration clause, or to confirm the nature of the dispute. And our ethos is to be as helpful as possible. And so to the extent we are in a position to confirm the information that is being sought, we do that immediately. The final thing that I want to touch on is the impact of COVID-19 on the implementation of the arrangement to date. So I mentioned earlier that we have seen 7 case orders granted, and we know that one is imminent. So what about the other applications? We do not know of any cases that have been declined. They are all currently pending to our knowledge. Amongst the applications that were granted, 4 of those were granted within a matter of days, the same day, 1 day, 2 days, or a week. And another 3 were granted between 1 and 3 months. But what we do notice is that of the applications that were filed in October and November 2019, those applications were dealt with the most swiftly. And the pending applications that we saw filed during the time when the coronavirus had a major impact in mainland China, those are the cases where we see the most delay. Under Article 8 of the arrangement, there is an obligation for the courts dealing with applications under the arrangement, both the mainland Chinese courts and the Hong Kong courts, to deal with the applications expeditiously. And we know that once the Chinese courts have been able to get through the backlog that they're currently dealing with, we think that we'll see these applications being dealt with swiftly as they were in 2019. So that brings me to the end of my presentation. And now it's my great pleasure to hand over to Helen Shi. Thank you.
Thank you, Farah. Good afternoon, everyone. It's good to learn that HKIAC has already handled 18 cases so far in only 6 months' time after this arrangement entered into force. Among these 18 cases, we handled 1 application immediately after this arrangement entered into force. I'm happy, to share my experience with the audience, and my role for this section is to introduce the practicalities of filing an arbitration for interim matters under this arrangement in the PRC court. I will cover the following issues: types of the interim matters available in the PRC, conditions for granting interim measures, competent courts, and the documents required for filing. I will also explain the timing and the security requirements involved, examining one of the HKIAC cases we handled as an example. At the end, I will share tips for handling such an application. So maybe let's turn to next page, next slide. Yeah. Types of interim matters available in the PRC, as mentioned by Sarah: assets preservation, evidence preservation, and the conduct preservation. Well, it's quite easy to understand the concept of assets preservation and evidence preservation. For the conduct preservation, this concept is very similar to an injunction on the common law system. The court can order the respondent to take or not to take certain actions. Let's turn to next page. Yeah, the conditions for granting interim measures, or requisites for taking interim measures. So what are the conditions for the court to consider in granting interim measures? For assets preservation and injunction, the court will definitely consider the enforceability of the future award. If the conduct of one party or for other reasons, the arbitral award may not be possibly enforced in the future, or may be difficult to be enforced in the future, then the court will be inclined to issue the interim measure, or issue the order for interim measures for assets preservation and the injunction. For preservation of evidence, the court will review whether the evidence is likely to be destroyed due to in certain circumstances. So this is the conditions to be considered by the court for this 3 available interim measures. Well, under the PRC civil procedure law and arbitration law, the party is also allowed to file the interim measures before the arbitration application is filed. Under such situation, the court will also review the emergency situation, whether the matter is so urgent for the court to take action. Let's turn to next page. The competent court. First of all the applications should be filed to the intermediate people's court. We have 4 levels of the courts in Chinese court system. The intermediate level people's court has the jurisdiction over the interim measure application under this arrangement. On the following, the court in the following 3 locations have jurisdiction over the interim measures application. The first one is where the respondent is domiciled. It applies to these 3 types of interim measures: preservation of assets, preservation of evidence, and injunction. Another kind of court is where the assets are located. It's easy to understand for the preservation of assets, and for the evidence is where the evidence is located. According to this arrangement, If the party, the applicant, want to file more than one application for interim matters, they may want to preserve the evidence and at the same time preserve the assets. Under such situation, the claimant must choose one court which has a jurisdiction to make the filing. No need to file two or three different courts for such filing. Let's go to next page. For the documents required for the filing, Sarah already introduced what documents required by the PRC court. One of the important documents is the certificate issued by the arbitration institution confirming the acceptance of the case, because the court wants to know whether the arbitration is already filed. And this information needs to be proved by the arbitration institution. Of course, as I mentioned, the pre-arbitration, the filing prior to arbitration, the filing for interim matters is also allowed. But so far, as Sarah mentioned, there is no such application at the current stage. And it's also very difficult for the court to grant pre-arbitration interim matters in practice. In order to obtain the certificate from the arbitration institution, you need to check with the specific arbitration institution. If the case is before HKIAC, HKIAC already issued a guideline and published it in its website. It's mentioned all the procedures and documents required to be submitted to HKIAC. Now the question is, who should be the party to file the application to the court? Is HKIAC or the applicant? According to the arrangement actually said the documents, the full set of the application material should be directly sent by the arbitration institution to the court. However, the interpretation and sending application of the arrangement issued by the Supreme People's Court provided an alternative way. Rather than have the arbitration institution sending the material to the court, it allows a party to file the application material directly to the mainland Chinese court, together with the acceptance and the transfer letter issued by the qualified Hong Kong arbitration institution. In my view, the purpose, as Sarah mentioned, is easier for the party to identify which court, which judge to be the contacting person. But I think another purpose is to minimize the workload of the arbitration institution to make sure the accuracy of sending the documents to the court. In our case, actually, the case we handled, we filed the application to one of the intermediate people's court in Shanghai, together with the acceptance letter issued by HKIAC. But the court actually insists that those documents should be sent by HKIAC directly. So we went back to HKIAC asking HKIAC to send the documents directly to Shanghai court. HKIAC did so. Let's go to the next case. Next page, yeah. So this is a sort of the timetable for the cases we handle. As you can see from the slide, we filed the application to HKIAC on October 8th, immediately after national holiday. And within 2 days, HKIAC issued the acceptance letter, which is very effective. We then submitted the whole package of our documents application to the local PRC court. And we also provided security to the PRC court. The form of the security we adopted is we use the insurance company to provide an insurance letter a guarantee letter to the local court. Well, in practice, this is a common way for providing insurance nowadays. The cost is manageable, and most of the court accept this form of as security. And within roughly a month, well, it took the court roughly a month to issue the interim order, and it take them 2 months to complete the assets preservation. In our case, we actually asked the court, the Shanghai court, to go to attach the assets in Shanghai, and we also identified assets in other provinces. So the court in Shanghai actually traveled to other provinces to attach the assets. So this is the timing and the security I'd like to share with you in our case, in handling our case. I think the time is running out very quickly. Let's go to next page. I would like to share with you the tips which we learned from handling this interim measures for HKIAC case. It's an ex parte proceeding, as mentioned by Sarah. When you apply this proceeding, file the application to HKIAC asking HKIAC to issue acceptance letter, you need to identify or informing HKIAC whether you want HKIAC to inform the other party or the tribunal. Normally, you don't want the other party know before you take action for interim measures. So this is an ex parte proceeding. If the other party does not agree with this ex parte proceeding, or does not agree with the interim measure orders issued by the PRC court, they have a chance to file a review process. For the preservation of conduct for the injunction, sometimes injunction or preservation for conduct frequently being used in intellectual property disputes in PRC, but not commonly used in commercial disputes. Therefore, if you consider it's necessary in our case to file an injunction or to apply for an injunction, you may consider other options. For example, emergency arbitration proceeding, which is also available under HKIAC rules. That might be an easier way to obtain a good result. Other tips including communication. Communication is very important because the court, PRC court judge, this is a new mechanism that may have many questions. So it's very important to keep communication. Well, I think my time is running out. So I will, leave all the rest of the tips here in the PPT. You can review it later on. Thank you very much.
Thank you very much, Helen. That's really interesting. And we have a couple of questions come through that we'll take up with you at the end. So let me now hand over to Ing Long. Thank you.
Thank you, Sarah. Good afternoon, good morning, or good evening, ladies and gentlemen, wherever you're dialing in on this rather dreary afternoon in Hong Kong and rainy. What I'm going to touch on is the flip side of what Helen has just dealt with, which is applications for interim measures in Hong Kong in respect of mainland arbitrations. So let me start off with my first slide, which covers 2 articles of the arrangement. Next slide, please. Thank you. These 2 articles are Articles 6 and 7 of the arrangement. And the one thing I wanted to point out on this slide is that contrary to the wording in respect of Hong Kong seated arbitrations, you will see here that under Article 6, the wording is arbitral proceedings administered by a mainland arbitration institution. So the concept is administration of the arbitration by an arbitral institution seated located in the mainland, of which there are over 200 to date, because the idea of a seat is not a very significant concept under mainland Chinese arbitration law. Article 7 points out the relevant materials and the documents that are required for purposes of making an application to the Hong Kong courts. For those of you who are from common law jurisdictions, you will be familiar with these materials or papers. They include the application, an affidavit supporting the application, relevant exhibits, skeleton argument, and draft court order. And usually these are prepared by a firm of solicitors in Hong Kong. Next slide, please. Article 7 of the arrangement goes on to specify what the application has to deal with. And you will see on this slide that there are 7 issues that the application should specify. I will leave you to read these in detail later on when the slides are made available. But what I wanted to highlight on this slide would be requirements 4, 5, and 7. Article 7.4 and Article 7.5, they mirror the full and frank disclosure requirements, which are the elements of an ex parte application for interim relief in Hong Kong. The reason they spell it out in the arrangement is because they wanted to emphasize in the arrangement to mainland Chinese practitioners who may not be familiar with the concept of full and frank disclosure, which is a critical element of any application to the Hong Kong courts for interim measures. The other point is Article 7, sub-bracket 7, which says any other matters. This suggests that the previous 6 items are not necessarily exhaustive, and parties should take advice on what are the requirements under Hong Kong procedural law, which I will deal with separately later on. Next slide, please. And obviously, when you make an application to the Hong Kong courts, you have to comply with Hong Kong law, which includes not just the arbitration ordinance, but also the rules of the High Court and Hong Kong judiciary's practice directions, particularly practice direction 11.1, which sets out the various procedural requirements for interim relief applications. And what I wanted to emphasize is that there is a difference between the approach of the mainland courts and Hong Kong courts. In Hong Kong, applications for interim injunctions have to be made by summons, supported by an affidavit, and the application is made to a High Court judge. And in many cases, these applications are made ex parte, without notice to the other parties if there are good reasons, or alternatively, you give notice and then you appear before a judge, usually the duty judge, as soon as the materials are given to the court and the judge has time to read them. There is an element of advocacy involved in that your solicitors, the applicant solicitors, or in some cases a barrister, will appear before the judge to make submissions. Next slide, please. This slide actually talks about the timetable for an application. So the application is made, and then if it is successful, the court will grant an ex parte interim order, and there will be a return date whereby the respondent may come back to court and apply to set aside the order. And there are specific sort of timetables and dates on which the court deals with these applications and setting aside applications as well. And obviously the party, the applicant, if he's successful, will have to give notice of the order to the respondent. And in the case of a Mareva injunction, you will be giving notice to the relevant banks as well, assuming that those funds are located in Hong Kong. Or if it is worldwide, you then give notice to the bank's headquarters worldwide. There will be cost implications, and usually the relevant order made by the Hong Kong courts in such cases will be costs reserved, meaning that the cost will be determined at the end of the entire hearing, i.e. the arbitral proceedings, and the tribunal does have the discretion to award costs later on. Next slide, please. This is yet another aspect of Hong Kong law that applies to applications for interim measures, the arbitration ordinance, section 45(2), and also section 45(5). You will see from the second bullet point that two requirements have to be specified, have to be fulfilled before the court can grant an interim measure. First is that the arbitral proceedings are capable of giving rise to an arbitral award that may be enforced in Hong Kong under the ordinance. And the second is that the interim measure sought belongs to a type or description of interim measure that may be granted in Hong Kong in relation to arbitral proceedings by the court itself. And the third bullet point emphasizes that sometimes the court may decline to grant an interim measure on the ground that the interim measure sought is currently the subject of arbitral proceedings, and the court considers it more appropriate for the measure to be dealt with by the tribunal. So here, the court does have the discretion to say, if you have already made an application to a tribunal for an interim measure, we will not interfere, we will not entertain the matter because it is more appropriate for the tribunal to deal with it. So you have to make a decision right at the outset which entity you want to apply to. Next slide, please. Here and in the following few slides, I'm basically just tying back the sorts of interim measures that Hong Kong courts can grant to tie that back to Article 1 of the arrangement. If you go to Article 1 of the arrangement, you will see that it sets out various types of interim measures. So for example, for the purpose of maintaining or restoring the status quo, pending determination of the dispute, or to require parties to take action that would prevent or refrain from taking action that is likely to cause current or imminent harm or prejudice. So under each of those sorts of descriptions, I have listed out the types of interim measures that a Hong Kong court can grant. So you'll see those set out in bold. Over to the next slide, please. This is a continuation of the types of interim measures. So to provide a means of preserving assets or to preserve evidence. And again, I have highlighted in bold what they are. Over to the next slide, please. Here, I go into a bit of detail as to what kind of tests does the Hong Kong court carry out to determine whether to grant an interim injunction or interim measure. And here, basically, again, it is a two-stage test, whether the facts warrant an order for interim measure if substantive proceedings were brought in Hong Kong, and also whether it would be unjust or inconvenient for the court to grant the interim measure. Next slide, please. And these are the general principles that I set out here for the Hong Kong courts to consider. Serious question to be tried, whether damages are an adequate remedy, and the balance of convenience. In the case of Mareva injunctions, the court also considers whether there is a real risk of dissipation or secretion of assets by the respondent. And that is often quite a high bar to the applicant. Next slide. And this goes into a bit of detail based on case law as to the other sort of slate of factors which a court takes into account in applying the test for an interim injunction. Next slide, please. This slide focuses on Anton Pillar orders, which is basically in the nature of preservation of evidence. And here I just wanted to emphasize that the test to be applied is even more onerous than the good arguable case, which is applicable to other interim injunctions, because the rationale is that here you are actually seizing documents or property in the possession of a respondent. So the applicant needs to discharge its very high bar of proving the case. Over to the next slide, please. This slide talks about Article 8 of the arrangement that deals with security for costs and also undertaking. Those of you who are familiar with applications for interim injunctions before a Hong Kong court would be aware that the applicant does have to give an undertaking as to damages in the event that the injunction is ultimately overturned or discharged. He has to be liable for damages. And also, in the same breath, in Article 8, the arrangement also makes it possible for a court to order security for costs to safeguard the interests of the respondent. Now, on my final slide, next slide, please. I touch here on the arrangement significance for users. Sarah has already dealt with it in her opening remarks. I just wanted to say that, sort of echo what Sarah said, in that in terms of applications to the Hong Kong courts for interim measures, this is not something new, because since the 1st of June 2011, with the enactment of the new Hong Kong Arbitration Ordinance, it has been possible for Hong Kong courts to issue interim measures in support of arbitration seated outside of Hong Kong, not just in Hong Kong, but also those outside of Hong Kong. However, what bears emphasizing is that in this arrangement, the two different sort of legal jurisdictions, the PRC and Hong Kong, have seen it fit to apply some sort of reciprocity in the arrangement in giving Hong Kong seated arbitrations applicants a chance to apply to the Chinese courts for interim measures. And the final point is that it gives parties entering into China-related contracts the additional option to seat their arbitration in Hong Kong, which is a well-known international arbitration hub. Thank you very much for that, for giving me time to make that very quick presentation. And I think our next portion is actually Q&A.
That's right. Thank you very much, Ing Lung. Before we turn to the questions that we received, what I would like to do is to bring up some slides that in summary format juxtapose the interim measures available in the Hong Kong courts and in the PRC courts. So here you see that presented. And here you see a similar juxtaposition of the considerations for granting interim relief between the two jurisdictions. And then in this final slide, you see some other aspects which compare the differences between the two jurisdictions with respect to application procedures, the challenge of an order, time frame for a decision to be rendered, the validity period, and costs. And we just put that there for viewers' information. These slides and the recording of this webinar will be available after today so that you can refer back to this information as needed. Okay, so thank you to all of you who sent in questions. I have one here which asks me, with respect to the sealed hard copy of the letter, Why is it sealed? Is that done for the parties, or is it a requirement of the PRC court? And in practice, would the applicant open the sealed letter to make sure that it really is about the case in question, to avoid turning up at the court and having the wrong letter? So my response is that in the beginning, when we issued our letter of acceptance, we did so not in a sealed envelope, but just by providing the original copy with our CHOP, and that was then given to the applicant to present to the court. But in one case, it was relayed back to us that the court did not feel comfortable accepting that and preferred to have the letter of acceptance in a sealed envelope. And so in light of that, we've changed our practice. I don't think that there's much risk that the wrong letter would be put into the sealed envelope, because we take great care in that. And also we provide to the applicant by email a copy of the letter of acceptance that we've put into the envelope. So that is just a reflection of, you know, something that we've tweaked in our own practice by the experience that we've gained with the courts. Okay, so the next question is for you, Helen, and that is with respect to one of your slides on tips, where you referred to legalization and notarization. Could you expand a bit more on that?
Yes. Normally for the documents generated in Hong Kong, for example, like the letter, for example, the certificate of corporation of a company, if you need to file these documents to the PRC court, this certificate need to be notarized by a notarization agent who is authorized by the Ministry of Justice of the PRC. But under this arrangement, the documents, for example, the letter to confirm the acceptance of the case issued by HKIAC would not need to be legalized or notarized.
Yeah, that's right. So it's the documents of identity of either the natural person or of the incorporation documents of a company that must be notarized, but those are the only documents that need to be notarized, not the letter of acceptance from HKIAC. The other thing to note is that all documents need to be filed in Chinese.
Right.
Another question for you, Helen, and that is in respect of the timing around the issuance of court orders by mainland Chinese courts. I spoke a little bit in my presentation about the differences we're seeing. For example, the very first application that came in was made to the Shanghai Maritime Court. It was filed and it was issued on the same day. But we've seen a bit of difference coming out of the other courts. And so this question is, putting aside for one moment the exceptional circumstances with the coronavirus, in your experience, what kind of time frames are you seeing mainland Chinese courts issue interim measures normally, so outside of the arrangement?
Well, I would say case by case. The case we handled in October last year, it took like around 40 days because the judge who handles this case was, she focused more on details and, questioned almost everything. So we had to go back to HKIAC to obtain additional letters and the proof. But normally for other cases, maybe not the interim matter, interim relief under this arrangement, normally PRC court will issue such order in a very short period of time, within, I would say, 1 week to 2 weeks.
Okay, thank you. And another question for you, Helen, is what is the typical amount of security that is required to post for the mainland courts?
Well, in practice, the court, if the application is for the preservation of assets, the court will ask the same amount of the request. So previously, the applicants normally will ask a bank to issue a guarantee letter, and it must be a Chinese bank. But nowadays, the court started to accept the letter issued by the insurance company is the full amount, still the full amount. Although according to the PRC law and the guidance, the Supreme People's Court interpretations, in certain cases, 30% of the security should be sufficient. But in practice, the court requested the full amount.
Okay, thank you. Inglong, I have a question for you, and that is, could you give an idea of the handling costs for Hong Kong solicitors running such an application before Hong Kong courts?
Yes, I'm happy to answer that, Sarah. Obviously, it depends on the kind of firm or solicitors that you instruct. And I would sort of venture to hazard a guess that it could range between somewhere in the region of US dollars, 50,000 to upwards of 100,000 US dollars for the application to be made, including showing up before the judge to make the application. Obviously, if you instruct counsel in addition to solicitors, then your costs are likely to go up.
Thank you, Inglong. I have one question here for me, and that is, has the HKIAC accepted applications under the arrangement in which the centre is administering the case under the ancitral arbitration rules? This is a very good question. The answer is no. All of the cases to date have been under the HKIAC administered arbitration rules. However, in certain circumstances, we would issue a letter of acceptance in respect of a case in which we provide administrative support under the ancitral arbitration rules. We have administered cases under the ancitral rules since the 1980s, and over that time we have developed procedures which set out the terms and the ways in which we perform that administration under the ancitral rules. And so cases in which the ancitral rules apply and our procedures apply, we would certainly issue a letter of acceptance. We also, however, have provided administrative support in ancitral cases where the procedures don't apply, but where that support is rather bespoke administration. And in particular, we provided that recently in an investor state arbitration where it was under the ancitral arbitration rules, and we came to a separate agreement on what our administrative tasks would be. So really, as long as there is administrative support being given by HKIAC that goes beyond discrete applications to HKIAC to perform appointing authority services under the ancitral rules, we feel comfortable issuing a letter of acceptance. But if any party has any doubt, they would be advised to contact us in advance. I would just conclude with the point that we know from case law from mainland China that the courts have recognized a case that is under the ancitral arbitration rules, which, as you know, is an ad hoc set, but which is being administered by a mainland arbitral institution, that has been considered to be an administered case. So that's my response to that question. Okay, now we have one more question for you, Helen. I think we have time for this. In practice, are there any specific requirements on the delivery method of the documents from the HKIAC institution to the PRC courts? Actually, now that I read the question in full, I think we have covered that in quite some detail already, and that really goes to the heart of Article 3 of the arrangement, and then the note issued by the SPC, which gives the official guidance to the courts, to users, and to the institutions as to how to implement the arrangement. I have to say that a lot of the other questions are whether or not the slides will be available after the session. I have mentioned that, but just to reiterate, yes, you can go onto our website and you can find there a way to obtain the recording of this webinar as well as the slides, and that will be posted there going forward, so that will always be available. And to conclude, I'm just showing here our upcoming webinars, and there is another one we will be adding to this series, and that is going to be held on the 15th of May, and that is with respect to our conduct of virtual hearings. Over the last couple of months, we have seen an incredible increase in the demand for e-hearing services. So we're going to dedicate a webinar to that, and that will be run by lawyers who work within HKIAC who have been closely involved with the technical rolling out of our e-hearing services. So we are now at the end of our hour, and it just remains to me to thank very much Helen and Inglung for their contributions to this webinar. Thank you very much.
Thank you, Sarah. Thank you, everyone.
Thank you, Sarah. Thank you for the audience as well.
Thank you.